Is it? Good afternoon, everyone. I hope now I am audible. Just confirm if audio and video everything is clear. Good afternoon, Yogesh. Am I audible now? Okay, thank you for your confirmation. Let's start the class. This is our fifth class on this topic, and in this series of classes, we are going to cover the complete polity syllabus from the mains perspective. What do I mean by mains perspective? That is, we are going to discuss the content from theme wise. So we will pick various themes. For example, in this today's session, we are going to discuss the theme of constitutional morality. We are going to discuss the theme of uniform civil code. So on any particular theme, we will discuss all the possible dimensions in which UPSC can ask a question in civil services mains exam. Okay, so in case you have missed earlier classes, you should go to the YouTube channel of Narayana IAS Academy. Under the heading N100, there is a playlist with this name. In that playlist, you can watch all the earlier videos. In case you have any doubt from our previous session, you may ask. See, these sessions are going to be interactive. I expect, the very purpose of it having a live session is that I expect from you to ask questions during this session, give answers to the questions that I ask, so that there is complete clarity about these concepts in your mind. Okay, so I believe everything is clear. So now I shall move towards the first topic of our day, that is constitutional morality. What do you understand by constitutional morality? If you have anything in your mind, please let me know. What exactly do you think that constitutional morality could be? As the name suggests, you can definitely make a guess from the name itself. The name simply says that there is constitution, and as per this constitution, what is morality? Morality is uh, some principles that tells you do's and don'ts. What should you do and what should you not do? So as per constitution, what are those principles that we should do or not do? That is simply constitutional morality. I mean, this is the meaning that we can understand by the name itself. Okay. Now, I will give you the definition that you can write. It refers to the principles and values underlying a constitution that guides the actions of both the government and the citizenry. Obviously, for whom? Who? I mean, when we are saying that should do or should not do, who should do or should not do? It is the government, and also it is the citizen. Both are governed by our constitution. So if both of them, what should they do or not do? What are those principles and values, and where are these principles and values emanating? They are emanating from the constitution itself. Okay. Now the next question that is that can be asked is, from where, or rather what are those principles and values of constitutional morality as per Indian constitution? See, it can be worded in two perspectives. One, it can be asked that what are the, in absolute term, what are the constitutional morality? Okay, what are those principles which must be part of constitutional morality? Okay, we have studied one concept, if you remember, that was constitutionalism. What was constitutionalism? If any one of you can give me an answer. What was constitutionalism? Satish, Yogesh, and AEIOU. I forgot your name again. Please post your name again so that I could have a better conversation or direct conversation with you. Yeah, tell me, what is this constitutionalism? In two words. Constitutionalism is simply limited government. So constitutionalism is, as we have also seen, that the constitution has the most important function is to put limit on the powers of the government. So from there also you can see the principles and values that will underlie any constitution would invariably be those principles and values which would put limit on the powers of the government. Can you tell me which are those principles which will put down limit on the powers of the government? Or this is what in itself a principle as such, limited government? So let's see. These are the facets of federalism. Fundamental rights, the right to freedom that people enjoys. Separation of power. Yes, Yogesh, you are right. So what are the constitutional? So first and foremost thing, facets of this will include, constitutional morality will include all the values which are there in our constitution. Any value that you can pick from constitution, you start the preamble, the secularism, sovereign, socialist, secular, democratic, republic, all these constitutional values are part of constitutional morality in India. Is it clear? Then rule of law. This is something which is explicitly not mentioned in. So first you must note down the values as mentioned in preamble. Second is rule of law. Where is it coming from, rule of law? It is coming from Article 14. Supreme Court has said that rule of law is implicitly there in Article 14. And rule of law also, whenever there is an arbitrary action on part of the government, it would mean there is violation of rule of law. In rule of law, no action can be arbitrary or unreasonable. Okay. Then the principles related to democracy, fundamental rights, separation of power, checks and balances, welfare state. These are the various facets of constitutional morality. But see, this is not, constitutional morality is not limited to this. Anything that you can bring from the constitution or anything which is mentioned in the constitution, any principle or values that is emanating from constitution would be a part of constitutional morality. I have just given you few examples. If you want, you can give a few examples in the chat section as well, just to test your IQ. Can you come up with any example other than them? Okay, one more thing, one more statement if I gave you, that constitutional morality emanates from the constitution, but it is nowhere written in the constitution. I mean, there is nowhere, there is a compilation that these are the values which would be called as constitutional morality. So as such, the whole constitution is the source of constitutional morality. But then again, who is going to tell, if the constitution does not mention a list of values or principles which are like constitutional morality, then who will tell us? You are right. It is Supreme Court which is going to tell us that which are the values. And this is something that has been done by the Supreme Court through some of the judgments. There are few judgments. Yes, basic structure. So there are few judgments which have mentioned the constitutional morality. This word has been mentioned in a few judgments. Let's see. Like the first is Keswananda Bharati judgment. This is like one of the first cases where this term, yes, judicial review, bilkul sahi, you are right. Even the basic structure, that is also right. So in the Keswananda Bharati case, the Supreme Court gave this doctrine of basic structure, that there is a core structure of our constitution that cannot be amended. Okay, so this is something which Supreme Court says, that this basic structure is a part of constitutional morality, and that constitutional morality is inviolable. Okay, so this is where this term originated, the word constitutional morality. Okay, then there are few other judgments also, and why we are studying it, this is also something that you should understand. In the recent times, see, one thing is constitutional morality, another thing is social morality. Morality is as such social concept, what we should do, what should we wear. Like in the last class we have discussed about hijab. Okay, hijab controversy is there, that whether girls should wear hijab or not. So society has a code through which it prescribes what you should wear, what should you eat, what you should speak and not speak, and so on. This is called social morality. Now, constitution is also there. Constitution is also prescribing various do's and don'ts, what we should do, what we should not do in public life, in private life, what are our rights, etc. Okay, what if there is a conflict between the two? The society is prescribing something else, whereas constitution is prescribing something else. In that case, what is to be done? So invariably, the courts have ruled, the Supreme Court has ruled that our duty is to enforce constitutional morality. In case there is a contradiction between constitutional morality and social morality, the constitutional morality is going to be enforced. There is no second thought. Clear? The same thing, for example, in SP Gupta case, this is also known as first judge's case. In this case also, a term came, the constitutional breach is a severe violation of constitutional morality. So see, that was the point of time when it was being discussed whether the autonomy or independence of judiciary is being compromised by the way judges are being appointed or not. Okay, so in that case, the Supreme Court mentioned that constitutional breach is a severe violation of constitutional morality. Next is the Naj Foundation case. In this case, Supreme Court, it is not the Supreme Court, rather it is the Delhi High Court, which said that constitutional morality should prevail over social perceptions of morality. Society might be perceiving gays as something immoral, but the Constitution gives them the right to privacy. The Constitution gives them the right to equality, right to freedom. So they have all the right to choose their way of living. Okay. Next, the same thing was reiterated in Navtej Singh Jauhar versus Union of India case, in which the homosexuality was decriminalized. This is something which happened in Supreme Court. This is something that happened in Delhi High Court. Okay, so the basic action which was taken was the same, that constitutional morality was given supremacy over societal morality. Okay, and this is Indian Young Lawyers Association versus the State of Kerala. This is the case is also popularly known as Sabrimala case. So in this Sabrimala case also, like the society was saying that women are not allowed in this temple, but Supreme Court says that right to equality which is enjoyed by the women supersedes the societal morality. So the constitutional morality ought to be preferred over customary values, traditions and beliefs. So after writing this case, we can simply conclude in unequivocal terms that Supreme Court has taken this position that constitutional morality is superior to societal morality, and in case of any conflict, the court is bound to implement constitutional morality. There is no second guessing at all. Is it clear? If you have any doubt, please ask. These cases are very important. See, you can write about all the things that you know, but if you do not give any example or any substantiation through these court cases, your answer will not be extraordinary. So to get that extra marks, you must mention these court cases. I would rather suggest that you should have a compilation of all the court cases at some place in the note, and based on that, you should keep on revising. And it's like the same cases are used various places. It's not necessarily like in the constitutional morality you have used, the same will be used also in case we have a question on women rights, etc. The same case can be used when we are talking about equality. Okay, so there are a few famous cases only which would be used at multiple places. Clear? Next question that can be asked is, what are the challenges to constitutional morality? Like constitutional is there, constitution uh, is prescribing various principles through which we are getting constitutional morality. Now, if I have to ask, what are the challenges? Why is it that the constitutional morality is not being implemented? So see, there are various actors which have the responsibility to implement the constitutional values. If those actors either do not implement what they are supposed to implement, or they extrude into the domain of other actors, then the constitutional morality is violated. Okay, you can write any number of points, but I will just give you a framework that, see, in case there is a political interference, one important actor is the political class. So if political class is interfering in the functioning of other people, maybe judiciary, maybe bureaucracy, maybe police, the law enforcement agencies, invariably the constitutional morality is going to be compromised. Next is judicial activism and judicial restraint. So in case judicial activism is happening, then we say that judiciary is going into the domain of legislature and executive. This is not in tune with the principles of constitutional morality. Like constitutional morality talk about separation of power. Okay. At the same time, if judicial restraint is being practiced, this is also not good. Like judiciary is expected to protect the rights of the judiciary is expected to protect the rights of the individual. But if judiciary is not protecting, or other judicial restraint is somewhat like justifiable word, if you are like, you can use this word rather than judicial restraint, committed judiciary. Committed judiciary is not a judiciary committed in the service of the people. It is a judiciary which is committed to the principles or policies of the government. Obviously, okay, that is not good, because if the judiciary is committed to the government, it may not be able to protect the rights of the individual, and protection of the rights of the individual is the most important duty of judiciary. Okay. Next is enforcement and compliance. So obviously constitution, this is, I mean, in this you can have various points that you can write. What are the reasons why some of the principles or values of constitution is not enforced? Like there is lack of awareness, there is delay in justice delivery, justice delayed is justice denied, there could be implementation gaps. Here you can write as many points as the space permits. Can you tell me a few points why some of the constitutional provisions are not implemented in a spirit? Letter and spirit, both are important. A few example at least. No. For example, when didn't get the question, I am asking the question that think how constitutional morality is not enforced properly. If we have to think of those situations, those regions where some of the principles of constitution is not properly enforced, not implemented. For example, when there is misuse of precedent's rule. Like this was an emergency provision. But when for political gain, president rule is being imposed or the duly elected government is being removed from the power, this is violation of constitutional morality. Misuse of ordinance provision, repromulgation of ordinance, this is also a violation of constitutional morality. When our fundamental rights are curbed, internet ban, this is violation of our constitutional morality. So there are various such principles, or like when economic justice is not being made, there is inequality, because constitutional morality says that there has to be a social justice, economic justice. If social justice is not there, there is inequality, or rather economic justice is not there, inequality, we will say that there is violation of constitutional morality. There are various instances that you can go quote. Simply keep the constitution in mind, start from preamble, go step by step through various parts of our constitution. You will get plethora of example mentioning how constitutional morality is violated, or how, from where the challenges to constitutional morality are emerging. Yes, Yogesh, governor holding the bill, that is also a violation of constitutional morality. Or like in the Delhi, when governor wants to rule, that is also a violation of constitutional morality. The constitution wanted a democracy and elected government to govern the city state. Okay. Note down a few of these examples. After this, we are going to start something more interesting, something about which you must have debated a lot, and I would expect a lot of input from you. That is Uniform Civil Code. You must have heard about it, debated it, discussed it as well. And like there have been two instances. One, this year Independence Day speech, our Prime Minister has said that there has to be a secular code, uniform secular code in our country. He has not used the word uniform civil code, rather he has used the word secular code. And before that, Uttarakhand has already become the first state, or if not the first state, but Uttarakhand has tabled a UCC bill, or rather this bill has got the assent of the governor and it has become an act itself. So these are the two instances. Since union government has yet not brought the uniform civil code, which of what is going to be its provisions, etc. In this class, I am going to take you through the bill passed by, or the act passed by Uttarakhand. The purpose of this is that obviously UPSC is not going to ask what has Uttarakhand done, but when I will take you through the various provisions of the UCC bill passed by Uttarakhand, you will understand the complexities involved and the various terminologies. As and when union government decide to bring about an UCC, the various terminologies which would be there, you will also be familiar. So it would help you in understanding and debating those things when, as and when union government brings that. Okay, the question will be asked about union government only, not about the Uttarakhand bill, but definitely the debate or the points of concern are going to be similar. So let's first understand what is UCC. So first thing first, we need to understand what is civil code. Uniform civil code means there is civil code. So in yesterday's class we have seen about criminal code. We have seen about BNS, BNSS. Okay, so those were criminal code. So if you have done a crime, what could be the penalty, or what could be the procedure to deal with you? How you will be penalized or convicted or sentenced? Okay, but there are matters which are not criminal in nature, which are a dispute between two different people. These are the matters that related to private rights like contracts, business, property, family relation, and inheritance. The things related to these are called civil code. And the idea of uniform civil code is that these things should also be like, we already have uniform criminal code. Irrespective of your religion, when you commit a crime, you are subject to the same court, same procedure, same police, same court, and probably the penalty could also be same. Okay, do not argue like, sir, someone who is rich, he may not, he may get well. Someone who is not rich, he may remain in jail. But that's practical aspect. Theoretically, our law says that there is going to be uniformity in criminal matters, but law is not same for these purposes. And when we are saying here uniform civil code, it is a set of laws that govern personal matters. See, what is included in civil code? It also includes contracts, it also includes businesses and other aspect of property. These things are already same. The contract act is already same irrespective of religion. So what is left or what is different from different religion is not all the civil code, rather only the matters which are related to personal things, that is marriage, divorce, adoption, inheritance and succession. These are the items which are currently dealt differently for different religions. So if, like, in Hindus, the way you solemnize the marriage is you take 7 rounds around a pious, what do you say, fire. But the Muslims do it differently. They say Kabul hai, Kabul hai. Christians do it differently. And so are some other religions as well. Parsis also have different ways. Similarly, the process of divorce is also different for different religion. Like we had something like triple talaq for Muslims. You say talaq, talaq, talaq 3 times and you can get talaq. For Hindus, that's not the case. There has to be a court procedure. Similarly, for adoption also, there are different norms for different religion. Inheritance, this is something which is the most technical aspect or difficult to understand aspect, and we know very little about it. I will cover it in a bit detail so that you understand the concept of inheritance and impersonal laws. Okay, and succession. So these are the items which are dealt differently for different religion. I will also give you a few examples. Then I will take the issue of Uttarakhand code. You will also understand the nuances. But before moving those things, let's understand simply why we need uniform civil code. Why is our Prime Minister saying that there should be a secular code? Secular code is simply, when there is a law which is same for all the people of all religion, it is a secular law. So when he is saying secular code, it means the same thing as uniform civil code. So a law which is same for people of all religion. Okay. Those of you who are online, please like the video and please share it with your friends so that they could also enjoy the learning, and they can enjoy the learning in live session. Okay. So if now give the next title as why do we need uniform civil code, or why do we need a secular code? And the answer is, the first thing is because the constitution says that. And you can see that this is the Chief Minister of Uttarakhand. When he brought this code, he was carrying the constitution. He was simply saying that I am doing something which constitution has instructed me. Where has the constitution instructed? In DPSP. Yes, in DPSP, Article 44 simply says that their state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Yes, you are right. And then there is this aspect which is there, which is the most important or the compelling reason why we should bring about the uniform civil code, because the current religious code that are governing the impersonal matter, they have certain provisions which did not provide equality to the women. Okay, for example, the triple talaq, you can, or some of the uh, other provisions that we are going to see, which are being considered discriminatory against women. Now, since some provisions are discriminatory against women, this is also a compelling reason that we need to bring about a reform in those laws, those codes. Okay. Next is that it will also bring about unity in our society, or rather in our country. So if everyone is governed by the same set of law, the differences between different religion will go down. Everyone will feel that oneness. There, it would promote the feeling of oneness. And also, the laws which are based on religion is not in tune with secular principle of the country. This is the argument that we shall give from both sides. Like for different religion having different, I mean the people from different religion having different code is not in tune with the secular principle of our constitution. Our constitution is secular, so there should be secular laws. Okay, that's the logic, that's the argument which are being given for bringing about uniform civil code. Okay, then the question that must come to your mind, that see, constitution makers, they wanted that there should be uniform civil code, and you must be knowing that our constituent assembly also acted as parliament. It made laws for that many years when it was in existence. So why didn't they didn't they made the uniform civil code, rather than stating the future generation that you should take endeavor? Like lawmaking was not like other DPSPs, which requires a lot of say money or resources. What was the reason that the Constituent Assembly did not bring about a uniform civil code and ask it as a DPSP? Can you tell me, any one of you? It will burden the society and government, क्योंकि उस time already division हुआ था इंडिया का based on religion. Yes, that's the reason. So why we have different civil code? Here also the argument is same, that a state is secular in nature, and a secular state should not interfere in religious matter. So personal, these are the personal laws which are have been historically dealt by religious tenets. So that's why secular state should not interfere in these religious matters. Okay. The second is that at the time of independence, there was fear that it will inalienate the minority community. There was already a division, there were already communal riots. So if the society is divided, society is going through the communal riots, at that point of time, making a law which will change the way minority community has been dealing through years, is going to create further discontent. See, whatever be the law that our parliament is going to make, invariably the Hindu community is in majority in parliament. So it would all, if you are changing certain ways or beliefs which are being performed by the minority community, they will always feel that, see, these majorities are imposing their ways, their customs on us. So this is the feeling that we did not want at that point of time. At that point of time, we wanted, or our leaders wanted, to create the confidence in the minority communities. Okay, and then obviously post-partisan volatile situation. This is also true even today. Even today, that is also one of the primary reason why we are not bringing. We will also discuss separately the challenges that will come in case we decide to bring about uniform civil code today. But this is historically, these are the reasons why we do not have uniform civil code. Now let's see what is going to be the challenges if we are to bring a uniform civil code now. First is that, what is going to be that uniform civil code? It is going to be a big challenge. To bring about a code which satisfies everyone, like all community accept it, is going to be very challenging. India is a multicultural, multi-ethnic society. And their norms, their traditions are very much varied. They varied from region to region, place to place. And in such a diverse society, to find a common law is extremely difficult. And see, the problem will not only be among minorities. Even if you bring about a change or try to bring about uniformity in Hindu society, it is going to be a big challenge. It will also affect our cultural diversity, and we take pride in the fact that there is university in diversity, sorry, unity in diversity. So that principle would be compromised if we are bringing about a uniform civil code. We are trying to do something called homogenization. We are moving towards a homogenized society. And the resistance will not only come from the minority community, the resistance will also come from the majority community. I will give you an example of the Uttarakhand code, then it would be more clear how resistance is going to come. Obviously, there is going to be a feeling of majoritarianism dominance. There can be social unrest, and there could be an impact on federal features. How? Can anyone give me how bringing out a uniform civil code is going to impact the federal features? Okay, first of all, can you tell me that these personal laws are in which list? There are 3 lists in our constitution, Schedule 7. So in which of those lists we have these personal laws? Yes, you are right. The item personal law is in concurrent list. And since it is in concurrent list, on this, both state government and central governments are empowered to make laws. And if central government bring about a uniform civil code, the state government may feel that their power to make laws for their people is taken away. And especially one major aspect here is with respect to scheduled tribe. When you are mentioning the challenges, do mention about the scheduled tribe. See, we have provisions in schedule 5 and schedule 6 which gives autonomy to the tribal people to govern their own culture, to protect their own culture. And if we are bringing about a uniform civil code, I mean, culture invariably include all those personal aspects, the property, the inheritance, the marriage, divorce. So these, the autonomy that we have given to the scheduled tribe people, that would also be compromised through uniform civil code. So these scheduled tribe people, they may not agree or they may not be happy with our uniform civil code either. This is something which you must write. Do not only mention about the minority community. Scheduled tribe community is also an important stakeholder which is going to be very unhappy with this uniform civil code. Okay. Now let's see some of the provisions of UCC of Uttarakhand. This will give you more idea about the how complex the issue is. Okay. See, first thing that is brought is that it made a uniform marriages. Like in other communities, like Muslims, do you know what is the minimum age of marriage as of now? In Hindus, we have 18 years for women and 21 years for male. In Muslims, puberty is the age of marriage. As per Muslims' personal law, if someone has attained puberty, he or she is ready for marriage. He is eligible for marriage. Okay, so puberty can come at different ages for different person, but usually, I mean, the modern population, they can get at any age above say 12 or 13 years of age. So after that, a boy or girl is eligible for marriage. Now this act says that the age of marriage would be uniform. For boys, it would be 21. For girls, it is 18. Here also, see, keep on writing the problems also. Here also there is a problem. The few people are saying that the age of marriage should be uniform for both the gender. Why this discrimination between boys and girls? Either make it 18 for both or 21 for both, whatever be the year, but this gender discrimination is also not valid. Okay, see the complexity that can arise. Now it bans polygamy. As of now, Muslim personal law allows polygamy, which is banned by the UCC. Okay, although like the polygamy is not very much popular, but still it is allowed, which would be banned. Okay, this is something good. Like women organization, they are also demanding this, that this should be banned. Now these are the certain practices which I was telling you, that certain practices which are discriminatory against women. So you can take the example of polygamy over there. Okay, and there are certain practices like child marriage is allowed. Okay. Then it also bans nikah halala. Okay, you might be knowing about what this practice is. This is also something which is derogatory to the woman, that if a woman gets divorced, she cannot marry the same person again without consummating with some other person. Okay, then it bans iddat also. Iddat is the period a woman must observe after the death of her husband or after a divorce, during which she may not marry another man. So there, after you have got divorced from your husband, or your husband has died, you have to observe a period of iddat in which you cannot marry another person. Well, this is something which is very a logical kind of concept. It is not completely illogical. Why? Because see, this is just to witness if the woman is not already pregnant. That time gap would ascertain that the woman the child that the woman bears in the future is the child that belongs to her new husband. Okay, so because in earlier days we do not have the DNA technology and all those things. Even today the DNA technology is not very accessible. It's not that everyone can access it. Okay, so that's why that was the logic behind this practice of iddat. Okay, so now the community would not feel very comfortable by banning these kind of practices which have some amount of logic. Like the practices which does not have much of the logic or logic in say current terminology or modern outlook can be very bad. I mean, there can be acceptance if you remove those practices. The practices which are logical in nature, it is going to be very difficult to convince the society to give up on those practices. Okay, and for these both nikah halala and iddat, there is 3 years imprisonment and fine up to rupees 1 lakh. So, and this is another problem when you are imposing certain penalty for uh, carrying out the practices that the community has been doing for years. This is also something where you can face resistance. So, see, suppose, I mean, today there is again another peculiar aspect which is there in Hindu Civil Code also. Hindu Civil Code says that the minimum age of marriage for boys is 21, for girls is 18. But suppose it so happens that there is a child marriage is consummated. There is either bride or bridegroom is below this minimum age. But the Hindu Civil Code does not say that that marriage would be void. Ideally, if the person is not eligible to be married, that marriage should have been void. After attaining the age of 18 or 21, that person should have been given the liberty to decide whether that person wants to continue in that marriage or not. But that's not the case. In Hindu Civil Code accepts that marriage as also a legally valid marriage even if one of the bride or bridegroom is underage. This is a problem that we have in Hindu Civil Code also. The Parsi Civil Code says that after attaining the age of 18 or the minimum age of marriage, that person will have the right to decide whether he wants to continue in this marriage, he or she wants to continue in that marriage or not. So there are certain good practices which are there in other personal laws that also we can adopt, and obviously this is going to infuriate the majority community also. Then succession is like who is going to take your property. Okay, now there are some terms that I want you to understand or know. Okay, that's why I have brought about this thing. First is testamentary succession. It means that when you, this is something that we very often see in the movies, that some person has written a will and through the will all the property has been given to some other person, adopted son and so on. Okay, so this is when a property goes to the next generation through a will written by the person. And the new Civil Code of the Uttarakhand says that there is no restriction on the property one can bequeath or to whom it can bequeath. Bequeath means simply to give. Okay, so whom should I give the property and how much of the property, that's up to me. Where is this problem? In Hindu Civil Code, it is not allowed that you can give up the ancestral property. Okay. In Hindu Civil Code, there is distinction in the property that a person owns. One is ancestral property and another is acquired or self-acquired property. So this is the property that you have bought through your money or in your lifetime. And this is the property that you have got from your ancestors. Now, Hindu Civil Code says that ancestral property is owned by jointly across 4 generations. Okay, 4 generation means you, your father's generation, maybe your son, or maybe either your grandfather or your grandson. Maybe 4 generations which are currently alive, they are jointly holding any property. So the ancestral property cannot be sold or cannot be given through a will, whereas the self-acquired property can be bequeathed through a will. This is something which is currently followed. So suppose your father says on any particular day that if you are not studying properly, I will not give you any property. In Hindi they say no, that बेदखल कर दूंगा जायदाद से. You can simply go and say that you cannot. You can only deny me the property that you have bought in your lifetime, the property that you have inherited. I mean, your father has inherited from his father. You cannot be denied. Okay, because you are co-parsonary. Is it clear? If you have any doubt, we can discuss about it in more simple terms. There are two kinds of property that your father can be owning. One that he has purchased in his lifetime, another that he has inherited from his father. In this property, you are a co-parsonary. It is held jointly by 4 generations. This is the property that cannot be sold by your father without your permission. That's why many a times you must have seen that a debate and discussion happen, that you buy a property from someone and then his son comes and claims that this property is his. Although you have paid money, you have bought some property, but still, since the document through which the property was sold did not have the signature of all the co-parsonaries. I mean, these co-parsonary could extend to 4 different generations. That sale is not valid. When you are buying or selling any property, be very careful. If it is an ancestral property, make sure that you get the signature of people from all the generations. Okay? But if you are buying something that was already sold to him, then there is no issue. Okay. Next is intestate succession. Suppose a person dies without making any will. In that case, what will happen? So it says that the children, the widow, the mother, father will inherit the property. So now it has been limited to 3 generations only, rather than the 4 generations which was the practice earlier. Only the children, the widow, the mother and father, they will hold it. Now, one more thing that has been brought here in this act is that equality. Sir, is generation में women नहीं है ना? As per Hindu Succession Act, नहीं, women are there. Hindu Succession Act gives equal rights to men as well as women. So all your brothers and sisters, they have equal right in the property of your father. And even, this is the amendment which was brought in 2005. After 2005 amendment, even the married sisters or other married daughters, they have equal right in the property of the father. Okay, before 2005 that was not the case, but after 2005 Hindu Succession Act was amended to give equal property rights to son as well as daughters. Okay. Now here, this is another controversial provision which is there, that it is saying that all the children, whether they are legitimate or illegitimate. So those who are the fan of Game of Thrones, they can correlate with this, that whether you are legitimate or illegitimate, they will have equal rights. Now this is also something which is going to be very controversial. Why it is going to be controversial? Because once you are saying that the person is illegitimate, the second marriage is not allowed. If the marriage is not allowed, the son or daughter born out of that marriage cannot have the legitimate right on the property. Okay, but this is the provision that is in. Now see, I'm just showing you the complexity that can arise, whatever be the provision. If you deny it, that the illegitimate child will not have any right in the property, then also there would be an argument that how come, what's the fault of this illegitimate child? That's not his fault. No? He has been brought into this world by someone illegitimately. But if you give them the child, then also there is a problem. So whatever be the code that you bring, there is going to be controversy. Then whether it is a biological child or it is going to be an adopted child or a child born through surrogacy, all have been given equal a status when it comes to succession, inheritance, etc. Okay, this is a good thing. There is nothing wrong in this. Then this Uniform Civil Code excludes the scheduled tribe people. We have just said you that among scheduled tribe there is a very large diversity. They are much more diverse than the uh, Hindu community itself or the number of religions that we know. So this Uniform Civil Code has altogether excluded the scheduled tribe community. Again, this is problematic. As such, the principles of Uniform Civil Code is violated. But yes, the principles as enumerated in Schedule 5 and Schedule 6, they are upheld if scheduled tribes are excluded. Okay. Now the next point is that now this is something which is coming because of the modern outlook, the way our society is growing. Now the living relationships are a reality in our society, and this code of Uniform Civil Code of Uttarakhand government says that registration of live-in relationship is mandatory. Now see, here is the dichotomy, that the code is not saying that the registration of marriage is mandatory. Even if a marriage is not registered, it is legitimate, equally valid. The same divorce and inheritance procedure, everything has to be followed. It is not mandatory to register the marriage, but the live-in relationship has to be mandatorily registered. So now see, here is also something where a controversy is going to erupt if it is going to happen on national scale. Has happened on the Uttarakhand national media, and the people are not much worried about it. Okay, and there is a jail or fine also for rupees 10,000 or both. So the point that you have to learn from here is that how you are going to regulate the live-in relationship, whether they are going to be given equal status on par with marriage or not. This is something which a new civil code will have to address. Okay, now there are some people who are criticizing. See, some criticism we have already discussed, some other criticism, like this live-in relationship point is very much criticized by the people. People are saying that the government is now intruding into the privacy of the couple. It could be considered a violation of right to privacy. Okay. And it also have a presumption that if a boy and girl is living together, they are engaged in a relationship. That is also a very, what you say, parochial thought, parochial mindset. So this is also going to be a debate between the parochial or other traditional thinking, traditional outlook, and the modern outlook. There is always going to be a tussle when you are going to regulate a new civil code. And then it is also against the freedom of religion. Why so? Because see, as we have discussed earlier, that when these matters have been traditionally been dealt by the religious tenets, the religious books, like in case of Hindus it is the Manusmriti, in case of Muslims it is the Hadith, and so on. So if we are bringing about a uniform civil code, definitely the freedom of religion that the constitution guarantees them is violated. Do you remember the article? Article for freedom of religion? Article 25. So that's all that we have to cover about Uniform Civil Code. If you have any doubt, it is not 22, it is 25 to 28. If you have any doubt regarding Uniform Civil Code, anything that you want to discuss, you may ask or mention all clear. So let's move ahead. Today we are going to bind up the class at 4 p.m. because after 4 p.m. we have DNA classes, daily news analysis. Watch that class as well, and do watch our YouTube channel. We would also be having a discussion of 2024 GS2 paper by Pratik sir. So if you are interested in that discussion, you may watch that. I have already taken the discussion of economic questions. The video is there on our YouTube channel. If any religious practice is socially evil, then it should be banned. Yes, so yeah, I missed that part. What is going to be our way forward? This is something that also you have to write, that obviously some items would be criticized one way or another. So what should be way forward? The way forward is first thing that you should not bring about a uniform civil code. Rather, we should have practice something like the way we have with respect to 73rd and 74th Amendment Act. We have certain mandatory provision and something called optional provision. See, how a person is getting married, it is not important whether he is saying kabul hai 3 times, or whether he is taking around a pious fire. It doesn't matter. So there are various aspects which are simply a part of culture. They are not related to constitutional morality. There are aspects which are not related to constitutional morality. They should be left to be regulated by the religious tenets, by the different personal law of different community. But there are few aspects of this inheritance. For example, all the sons and daughters, they should get equal rights. There are certain practices which are derogatory to the status of women, practices related to child marriage. So those provisions which are related to constitutional morality, they should be brought uniform for all the religions. And the other provisions which are just a matter of culture, they are not in violation of the constitutional principles. They should be left to be dealt differently for different religions. So we should have a, what you say, mixed approach, the way we have done for the 73rd Amendment Act, that some provisions which relate to constitutional morality should be mandatory for all the community, and some provisions which are not relating to the constitutional morality, they should be left optional for different communities. Okay, and the second thing that you should have is, you should not make Hindu civil code as uniform civil code. Why? As I have given you the example of child marriage, that there are certain things which are illogical, which needs to be improved. There are certain things which are better in other personal laws. So we should adopt those things from other personal laws as well. So we should have a comprehensive review of all personal laws, and we should, one more thing, that we should give a modern outlook to our civil code. When we are sitting now and deciding what should be the new civil code, at that point of time we should not be bogged down by tradition. Rather, we should give a modern outlook to our civil code. Okay, so these are the points that you will say, that one, never think of making the, because see, if you make simply Hindu civil code as uniform civil code, this is going to be considered as an imposition on the minority community. So you should do a comprehensive review. You should bring about the tenets of other civil code which are good, which are more modern in nature, and have a modern outlook in the new civil code. And this civil code should also have two kind of provision. One is mandatory, which are related to the constitutional morality. Another should be optional, which are not related to constitutional morality. So all those practices which are derogatory through the women, which are a violation of our right to equality, right to freedom, right to privacy, those practices from all the civil code should be removed. They should be outlawed. Is it clear? Let's see what Yogesh has to say. Women from certain religions always get exploited through various practices. That's what I'm saying. That those practices which are like derogatory to the woman, they should be abolished, and those practices should be brought in tune with constitutional morality. Is it clear, Yogesh? Next, we are going to see right to constitutional remedies. Now, this is something that you must be knowing. You will tell me rather than me telling you. What is the article number? Quickly answer me. What is the article number? 32. What does Article 32 says? The right to move the Supreme Court for the enforcement of the rights conferred by Part 3. So Part 3 mentions various fundamental rights. All those rights has to be enforced by, or rather a person has a right to move to the Supreme Court in case any of his right is violated. So in other constitution, this is something which is implicit in nature, because obviously rights has been given, then it has to be enforced. Okay, see, it is same thing, like as such directly nowhere it has been said other than Article 13 that the laws which are inconsistent with the provisions of the constitution would be declared null and void. Article 13 only talks about the laws which are inconsistent with the provisions of Part 3. Okay, but what about the other provisions of our constitution? Can a law be inconsistent with those? Obviously not. So the very fact that we have a written constitution, it means constitution is a supreme document and no law can be violative of the constitution. It is implicitly true. Okay, so judicial review is to a large extent implicit in nature, that because we have a written constitution. But for fundamental rights, it was made explicit under Article 13. Similarly, for fundamental rights, the right to approach the court has also been made explicit, and it has been written as a fundamental right itself. And to make it more prominent, to give it a distinctive flavor, the right has been given to move Supreme Court directly. Otherwise, you have to go through the lower court, then to the high court, and then to the Supreme Court. But in case of fundamental right, one can directly approach the Supreme Court, and then Supreme Court shall have the power to issue direction or writs. Can you tell me the writs which are available? The writs which are available to Indian citizen. First is habeas corpus. Habeas corpus means bring the body. So suppose a person is in illegal confinement. Okay, what is implicit and explicit? I'm just thinking of an example. Explicit, that is something. Explicit is something which is directly written. and implicit is something which is not directly written, rather understood that this is something which is gonna happen. For example, nowhere it is written that you should behave properly in the class. There is no law or no book that you should behave properly, or you should listen to me, or you should answer my question. But this is something which is implicitly that if you are in the class, you will answer to my questions. If you know it, you will behave properly, you will listen to the teacher. But what could be explicit is that until or unless you subscribe to the channel, you cannot reply on the chat. This is explicitly that YouTube writes in its conditions of service. So something which is explicit, that is written in the constitution. So that's what I'm saying. It is explicitly written in the constitution that any law under Article 13 explicitly writes, there are words which says that any law which violates any provision written in this part, that is part 3, shall be unconstitutional to the extent of inconsistency. But there is no such article which says that any law which is in violation of, say, Article 365 or Article 74 would be declared unconstitutional. But still, if any law is in violation of any of those provisions, it would be declared unconstitutional. Okay, for example, Article 123 gives right to issue ordinance to the president. But suppose a district magistrate issue an ordinance, it would be declared unconstitutional because he is not having right. Or rather, in place of president, if a minister is issuing an ordinance, it would also be declared unconstitutional because a minister does not have the authority to issue an ordinance. It can only be issued by president. But it is not written explicitly anywhere. I hope I am clear. Yogesh? Next is habeas corpus. Habeas corpus means bring the body. So if a person is unlawfully detained, like police has taken you into the custody and without any reason, no FIR is there, no magisterial permission is there beyond 24 hours. In that case, what can happen? That you can go to the court and say that he has been illegally confined. His right to freedom is, or rather right to life is taken away. So the court will issue an order to release that person. Okay. Next is mandamus. Mandamus is direction to perform certain legal duty. For example, this is the right under which PILs are filed in the court. That the Delhi government has the responsibility to give a pollution-free environment. Please issue an order to the Delhi government to clear the pollution. Okay. That is mandamus means order, to command. Next is quo warranto. So the chances are less that a simple question, direct question will come. But if a direct question comes, you have to give the meaning of these writs as well as you must write the example. So with respect to every writ, I am giving you an example. You must write the example also in the exam. Then only your answer is complete. Quo warranto is by what authority? To challenge the legality of a person holding a public office or position. So suppose you feel that certain person, like there was a recent case that an IAS officer who was not actually belonging to the physically handicapped category, but she took reservation through the UPSC by forging the certificates. Okay, suppose you have a feeling like that. Then you can go to the court and say that my right to equality is violated. I was unfairly treated. That person does not have the authority to hold the position as an IAS officer. So you can file a writ of quo warranto. No, writ, कोई भी written order किसी के भी against हो सकता है. So now you have to make sure that who is violating your fundamental right. If the right is related to untouchability, so untouchability is practiced by some other person. So in that case, that person के against भी writ दिया जा सकता है. but it varies from writ to writ as well. For example, habeas corpus can be issued against the state as well as non-state. Some certain non-state actor can also infringe your, detain you illegally, but mandamus can only be issued against state. Okay, so it varies from writ to writ. Quo warranto, it is challenging the legality of a person holding a public office. So since it is like public office, it can only be issued against the state. It cannot be issued against a private individual. So it varies from writ to writ. Certain writ can be issued against the state. Certain writ can also be issued against non-state actors. Prohibition, it is against the lower court or tribunal. Prohibition means prohibit from doing certain thing, so exceeding its jurisdiction. Suppose a court is dealing a matter which is beyond his jurisdiction, then you can say that the rule of law is violated, your rights are violated. You can go to the higher court, maybe Supreme Court, and request for the writ of prohibition. And certiorari, the difference between certiorari and prohibition is that in case the judgment has already been delivered, you are not happy with that judgment, you feel that that judgment is wrong, then you can go to the under certiorari writ to review the decisions of a lower court, tribunal, or a quasi judicial body. So the only difference between prohibition and certiorari is that in certiorari there is element of certification, there is an element of reviewing. Order has already been delivered, whereas in prohibition the order has not been delivered, the matter is still sub judice, but you feel that the court or tribunal is exceeding its jurisdiction. Okay, so if the matter is still in, say, Patna High Court, then you are going to the Supreme Court saying that the court does not have jurisdiction, you will have prohibition writ. Whereas if the Patna High Court has already given the judgment, then you are going to the Supreme Court saying that our rights are violated, then you will use certiorari writ. Is it clear? All the writs? That's all in that. Then we will have right to property. I will just give you a small brief about the right to property. In detail, we are going to study in tomorrow's class. In tomorrow's class, we are going to study the Constitution Amendment, the basic structure. There has been a lot of questions around basic structure and Constitution Amendment. So we shall discuss about the debate, the various court cases that have happened and through which that have culminated into the Kesavananda Bharati judgment. Okay. So what is this right to property? Right to property was there in Article 31. It was a constitutional right. Now it has been removed from a fundamental right. Can you tell me the Constitution Amendment number? No. There is a difference between appeal to Supreme Court and certiorari rights. See, when we are mentioning certiorari, it is under the writ jurisdiction of the Supreme Court. Okay, so it might be a case that the court which has earlier given the judgment might not be High Court. Suppose there is a tribunal, suppose there is a lower court. From that, you can directly go to the Supreme Court. Okay, under certiorari writ jurisdiction. Whereas in appellate jurisdiction, you go only from High Court on appeal to the Supreme Court. So there could be some commonality. Sometimes it may happen that the court which has given the earlier judgment was a High Court. So you have a choice. You can go under certiorari writ jurisdiction or you can go under appellate jurisdiction. But overall the concept is different. In certiorari writ, when you file, you are directly going to Supreme Court from any other court. You have to establish a case that your fundamental right is violated. Then you can go for certiorari. Whereas in case of appellate jurisdiction, there is no need to establish that your fundamental right is violated. For any other law, if it is violated, for any other right, legal right you are violated, you can go on appeal from High Court to Supreme Court. And for appellate jurisdiction, the High Court must certify that the matter is fit for appeal. We shall study these things in judiciary chapter. You can go on appeal only if it is certified by the court that the matter is fit for appeal. Whereas in writ jurisdiction, you need not get the certification of the High Court. You can simply go and convince the Supreme Court that my fundamental right is violated. If Supreme Court is convinced, it can accept your matter that yes, your right is violated. Let's see if we can issue the certiorari writ or not. I hope it is clear. Okay, so this is something that we are going to cover in tomorrow's class again. Today's class we are winding up here only. If you want to connect to me, you can connect to me through various of my social media handles. The handle for all of them is same as Madhusudan_IIT. Okay, see you again in tomorrow's class from 2 p.m. Today there was a technical difficulty because of which we could not start the class at 2 p.m. Our timing is 2 p.m. only. Today is going to be the last class before Dasara. After that, we shall go for the Dasara vacation. We shall start the classes after Dasara. Tomorrow, we have a class from 2 p.m. to 4 p.m. in which basic structure, etc. shall be discussed. Okay. So, goodbye. Take care and do like the video. Do share it. Do bring your friends. It would be much more pleasing experience for both you and me if we have more students talking live. More doubts will be answered. There will be more enriching discussion. Okay, so see you tomorrow. Have a good day.